case is Public Supermarkets versus Colin Ross.
Morning, may it please the board. Edward Dennis on behalf of the petitioner, Public Supermarkets. In addition to the work product issues presented here.
Excuse me, sir. 5 minutes.
Oh, I apologize.
That's no problem.
3 minutes.
3 minutes. Okay.
Thank you. Thank you for the reminder. In addition to the work product issues that are presented in this petition, it also raises two broader concerns. And that is, in this instance, the trial court's complete failure to limit, modify, restrict in any way whatsoever the 11-page corporate representative deposition notice that Mr. Roth presented.
Well, only required to go back 10 years, right?
Only 10 years because
Well, that's a limit.
Mr. Roth apparently was trying to be fair, according to the record.
So 10 years for 13.
100 stores.
Or 100.
1,300 stores over 10 years. And the second related issue, and this is a broader systemic concern, is the apparent insufficiency of guidance that trial courts have when confronted with Section 768-0755, the legislature's mandate as to what must be proven in your average slip and fall case. And these types of corporate representative deposition notices, because, and I say apparent with a certain amount of respect, because the trial court here ignored sometimes, even though it was binding precedent as the only district court of appeal decision on the subject. So apparently something is getting lost in the translation, something is not assisting the trial courts in understanding the interplay between Section 768-0755 and the scope of discovery.
Well, the trial court felt that, you know, you still have the right to assert the work product privilege and the relevance and all that at the deposition.
Well, as Your Honor well knows, relevancy is not an objection to deposition, okay? Regarding the privilege, public readily acknowledges if the question were merely one of a witness saying, I'm not going to testify because that is privileged information, that would be fine. But the problem is that the court's order also compelled publics to produce all of the documentation 24 hours before the deposition. And the contention publics raised is that all of that information that's in those incident reports that would have substantiated.
So is your argument that because publics categorically made the work product objection, you fall within the Avatar case that says the obligation to file the privilege log lest those objections be waived is not mature or wasn't mature?
Yes, Your Honor, absolutely. And it's interesting because this isn't the requesting question here wasn't merely a production request or a document request that happened to capture work product information. This request targeted specifically post-accident, post-incident investigations by publics. I mean, the universe of those documents
In
were
a
the very
perfect
things
world, in a perfect world, could Publix or should Publix, would your case be better if Publix had done some sort of a log to give the trial court an opportunity to perform an in-camera review or at least a sampling or give it to a magistrate for an in-camera?
in a perfect world, possibly, if we weren't dealing with conceivably 65,000 incidents over a 10-year span, if that kind of, if this had been a situation, let's say, where the request of it, we want 2 years of incident reports pertaining to the store in question. Well, Publix could have said, well, we had 10 such incidents. And you could identify it. How could Publix even begin to take that initial step of saying, well, let's see what this fight is about when you're talking about more than 1,300 stores over 10 years, it's impossible. So yes, in an ideal world, it might have facilitated things, but there's no way Publix could have gotten to that step before the trial court should have at least narrowed to some extent the scope of the request. And I think that's what Avatar Properties gets to. This notion is that when you come before the court and you have work product issues and you also have this overbreadth concern, how is the defendant or how is the party supposed to say, I can determine now what's at issue. I can determine which documents are privileged when everything is fair game. And so that's why I think we squarely fall in Avatar Properties. This particular notice of deposition and document request was so grotesquely overbroad that it brings us into the whole notion of this carte blanche. But before I dive into the carte blanche issue, let's talk about the things that are apparently conceded as having been improperly allowed, because the answer brief doesn't talk about it. And that's all of the information that was sought that was implemented by Publix after the accident. In other words, there were requests that we want all your policies and procedures enacted or adopted after this incident occurred. Camera positions, everything that occurred after the
So
accident.
is it Publix's argument on the after materials, that those are all entirely off limits based on general relevancy and or the statutory boundary that is articulated in Santos?
Well, certainly the statutory boundary, because and we haven't heard yet in any of the briefs or in the court below how any of that information can remotely help establish how it could possibly lead to relevant evidence regarding what Publix knew or should have known, actual or constructive notice, about the condition on the day the incident happened. I mean, what difference does it make where the cameras might have been repositioned 6 months after the accident? How does that even come close to addressing what the legislature has said is the governing standard for these slip and fall cases? So, and as I said, I think that issue is pretty much conceded because the answer brief doesn't even try to justify why that accident information is relevant. But let's talk more broadly about the carte blanche concern.
I want to ask one question relating to the subsequent remedial measures aspect of this. To the extent that a fall might have been prevented by better slip coefficients, materials applied to the flooring, would that be discoverable in the context of this case?
No, it was never planned. The only issue that's in the complaint is Mr. Roth's allegation that Publix was negligent because it allowed water to remain on the floor.
So there was no allegation that the floor was excessively slippery?
No, absolutely not. I mean, this is discovery on unpleaded theories. On the notion, and trial counsel basically said, well, Your Honor, everything's fair game because this is discovery. And that simply can't be the case. Because this is, I mean, if they had alleged somewhere along the floor, somewhere along the way, the type of flooring material that Publix selected for its floor is inherently dangerous.
And as far as our record shows, there's been no expert deposition or expert offering to suggest they want to make a determination whether they can plead such a cause of action. I mean, there's not, the chicken and the egg, what comes first? Do you do due diligence to investigate, which in a flooring situation, if there have been remedial measures, you can't go back and test what was there at the time. But if you had an expert saying this floor was too slippery, discovery might be appropriate, but we don't have that in this record.
Conceivably, and to directly answer your question, it's not in this record. There is no such basis. I want to be careful. I don't want to concede in any way, shape, or form that under the new statute, under 7680755, this kind of mode of operation theory is still viable. My contention is that when the legislature got rid of the predecessor statute, which did specifically mention mode of operation as a method of proving liability, it eliminated that. So to come along and say, well, Publix, you had a method of operating, you operated your stores with a type of floor that was defective. Now, if there were no transitory foreign substance, but let's play with a hypothetical for a moment. Let's say there were no transitory foreign substance, and therefore 768-0755 doesn't come into play. It was something else. The floor itself was defective, right?
No, but it could be a defective floor, which is particularly slippery if a piece of spinach falls on it. Or a banana peel. But again, I'm not sure we have that in this.
It certainly isn't, Your Honor, and I don't mean to get engaged in metaphysical debates over what isn't this case, because this record certainly doesn't establish that. We have got a situation here, and I want to highlight, and I'm sure the court is aware of this, what we say in our brief. A corporate representative deposition is an onerous obligation in discovery. As the court well knows, the burden placed on Publix or any other corporate employer in a corporate representative position is a serious one that can carry with it sanctions. So when a corporate representative deposition notice is issued with more than 80 topics and 21 document requests in a slip and fall case, covering, because the plaintiff made no effort, Mr. Roth made no effort to narrow it, 1,300 stores over 10 years.
We have spent a lot of time talking about how onerous this is. But drill down on how this is an essential departure from the requirements of the law. Be very specific about it.
Well, absolutely are. In Langston, and then subsequently in 2012 in Board of Trustees, the Florida Supreme Court reminded us that generally overbreadth is not a basis for certiorari review. But when the discovery in question amounts to, and this is their terminology, the carte blanche access to irrelevant discovery, when that happens, that opens the certiorari review standard. And the third district in 2016 in Santos took Langston to its Board of Trustees in the context of a section 768-0755 action and said, asking for only 3 years of information for all of Publix's stores in Florida was the kind of carte blanche discovery of irrelevancy, because it doesn't tie into the statute. And the statute, the way the third district reasoned it is, the legislature, when it enacted the statute, said what is relevant is whether or not the business establishment has actual or constructive notice of the dangerous condition.
So what if
and can remedy it.
if your opponent had requested this information for 10 years at this store only? Same document, same categorical requests, but pertinent to this store. That would satisfy Santos, wouldn't it?
I would be much harder pressed, Your Honor, to argue that kind of, because then all I'd be in here is arguing the difference between 3 years and 10 years.
And the reason I'm asking that question is to build on what Judge Morris asked you, which is, where is the departure from essential requirements of law? And what the court held, the holding of Santos, was the departure was requiring Publix to produce incident reports for stores other than the one that was where the accident occurred with
Correct.
Santos. And so that gives us only a bit of a splinter in what I think you need to make more of a log out of for irreparable harm.
Well, first of all, I mean, let me not gloss over the notion that irreparable harm also comes from the production of privileged documentation. I mean, that is a separate issue. We have been required to produce documents protected by work product, and that opens the jurisdictional door. Separately, let's set that aside. Let's say that we weren't dealing with work product issues. The fact that Publix is being asked to produce documentation or is being forced to produce a corporate representative who can testify about these thousands and thousands of incidents that do not relate to the statutory standard because they are not concerned with what the business establishment knew or should have known under the circumstances, then that's the irreparable harm. That's where it isn't merely a bit of overbreath. I'm tempted to say that this isn't a question of carte blanche, it's a question of a fire hose trying to put out a candle. Okay, because that's what's happening here. You have a request that goes so far beyond what could ever possibly be connected to the proof required by statute, that it crosses that line.
And the irreparable harm associated with that is that, and I'm just trying to make sure I understand your sort of projection to this. It's not the cost of producing, because Publix could do that. They could.
Theoretically, yes.
Yeah, so Publix gets in a lawsuit with Winn-Dixie over, antitrust issues, they're gonna be able to do it. I'm sure of that. But I think part of what you're arguing on the other irreparable, that's not your primary argument, not the burden of doing it, although we've talked about that a lot. I think part of what you're arguing is that the plaintiff then sets up a fishing expedition for a bunch more cases. Is that part of your argument, and that is a big piece of the irreparable harm?
Yes, it is, because what we have is this, and I allude to this in our briefing, which is that there is this pushback against the statute, which was intended by the legislature to sort of streamline, constrain these slip and fall cases to a concrete determination. Did the business establishment know or have reason to know that the dangerous condition existed and should have fixed it, should have corrected it? What we're seeing in a corporate representative deposition like this is flinging wide the doors to anything and everything that might conceivably connect to Publix's operations.
You're at 17 minutes, just so you know.
Oh,
It's your time to use it.
No, I understand, I appreciate that. I mean, there's so many examples in the deposition notice. Just the notion, for example, we want to see your tests. We want to see your hard copy tests and online tests that you give to employees on the training on policies and procedures. It's an infinitely slippery slope, not to borrow a slippery floor scenario, but that's where we find ourselves. And if there aren't some parameters set up for this, then what the legislature attempted to do in enacting the statute becomes meaningless, because plaintiffs will come in and try the cases based upon a boundaryless set of criteria. So we would respectfully request that the court quash the trial court's decision and remand. And I'll reserve what I have left.
You have 2 minutes.
Thank you.
Good morning, Your Honor. May it please the court. My name is Sam Alexander, and I represent the respondent, Colin Rao. As an initial matter, we haven't conceded anything. We don't concede that anything is privileged because there's been no determination of privilege. There's been an assertion of privilege from counsel, but there's been no determination of privilege by this court or the trial court.
Is it fair to file a privilege log fatal?
We contend that it means that the issue is simply not preserved for review by this court. And in the case they cite, Avatar, the trial court made a ruling on the implications of the non-existence of a privilege. They said you did not file a privilege log, therefore your claim of privilege is waived. In this case, the trial court was never given the opportunity, it didn't do it sua sponte, and it was never requested to make any sort of ruling on the implications of a privilege law.
What about the carte blanche argument? 1,300 stores over 10 years, that's a lot of stuff.
It is, but relevancy and overbreadth are in general, there's a general rule that objections that are overruled are not remediable on certiorari review. So there's an exception to that rule, the Langston and the Santos cases. And this case does not fall within Santos. And for the simple reason that Santos dealt with the trial court's construction of 768.0755 subsection 1, actual constructive notice. And the court in Santos made it very clear that the trial court's order in that case was, quote, limited to its interpretation of section 768.0755. That's not the case in this case. And
Well, I'm not sure that I entirely agree with your description of what the third district held. To me, distilled down to simple terms, what the court explained is that in a case like this, you're not entitled to discovery on actual constructive, except with respect to incidents at the store in question. And as we've talked about already, 1,300 stores is a lot of stores to have produced all this documentation for purposes of your client proving that Publix knew at this store, knew or should have known that there was a transitory substance in the produce.
that's not what the discovery is limited to intending to prove them. And I think this goes to kind of the heart of this case, is there's a conflation occurring here on Publix's part of actual and constructive notice with breach, and they're not the same thing. In passing 768.0755 subsection 1, the Florida legislature required plaintiffs in transitory slip and fall cases to prove actual and constructive notice and that the store should have remedied the situation. That is a requirement of proving breach of their duty of care, but it's not necessarily sufficient. So there's a gap that exists between proving actual and constructive notice and potentially proving negligence. So for example, we could imagine a scenario where there was a transitory substance in front of the blueberries and it was discovered on camera within 3 minutes, and Publix immediately dispatched someone to clean it up, and within those 3 minutes, someone slipped and fell and injured themselves. With discovery limited to that store alone, Publix has a very persuasive argument to the jury that they can say, well, yes, there was actual notice, but we acted reasonably under the circumstances and there was still no negligence. Well, what if discovery of a more broad discovery of other Publix stores shows that there are regularly spills in front of the blueberry section, and there regularly people are injured within 3 minutes of those spills occurring? Then all of a sudden there's a more specific duty of maintenance that Publix has of discovering these more quickly or preventing them or ensuring that there is some sort of permanent fixed sign warning about the potential. So simply because there's actual notice does not necessarily mean that there's negligence.
But at this point in this case, isn't that speculative? I mean, it seems to me that first the discovery that would be relevant and directly relevant would be what happened, when did it happen, who knew about it, how did they know, what should they have known, what should they have done? And then if it turns out it was let's say 4 or 5 minutes on the floor and they don't have enough people circulating in the store to look to see if there are problems, wouldn't that potentially open the door to additional discovery or an expert saying, under typical standards, that is an excessively long time? And even then you get into questions of, well, are you pursuing negligence in that store? Or are you pursuing punitive damages?
So you're pursuing negligence, and this is what the Santos court made clear, is there are 2 parts of subsection 768.0755. And they really expressly limited their decision to subsection 1. And they distinguished it from subsection 2. And they said in subsection 1, dealing with active and constructive notice, discovery is limited to the physical establishment. Subsection 2, which involves the duties, the untouched common law duties owed by the owner or possessor of the premise. And they said that's a much broader run. It's a much
But
broader.
it still goes to that particular premises. It doesn't go to a broader corporate policy, at least not at this point, I don't think it does it?
But the defendant in this case, Publix, the corporation, not a physical establishment. So the question is whether Publix, the corporation, has been negligent. And while the legislature has placed this requirement that the local physical store had actual or constructive notice of a transitory substance, that doesn't mean that evidence that Publix as a corporation was negligent in routinely, let's say, failing to prevent or
But that goes to the question, or the part of the question that I referred to as far as punitive damages. If there is a pattern of gross misconduct on any entity's part, that might support a claim for punitive damages because they're ignoring a known dangerous repetitive condition throughout their stores. We don't have that here. And Publix, there's no allegation in this case that Publix is subject to a punitive damages claim, whether they've engaged in gross misconduct like that. So, I mean, it does seem to me that some of the discovery you're asking for is beyond what is at issue in this case right now.
That may be this court's view of the discovery order, but there's still the jurisdictional threshold of irreparable harm, the general rule that overbreadth and relevance.
Well, how about privilege and work product?
So I think we should be careful to distinguish all of the various aspects of the order because they're all governed by different standards. So we would say that there's kind of 4 quadrants to this order. There's the deposition testimony, which can be broken up into a relevance objection and a privilege objection. And then there's the document production portion of the order that is also subject to a relevance objection and privilege objection. So if we're talking about the document production privilege aspect of the order, we maintain that they have not preserved this issue because they never requested.
There are cases though that say that that a party does not have to do a privilege log until other preliminary objections are first resolved, such as overbreadth and relevancy.
Yeah.
So, or is it likely to lead to the discovery of admissible evidence? So if we stay with that case law, this court has followed that or has adopted that approach, then the privilege log is not, the failure to provide a privilege log does not amount to a waiver or lack of preservation.
Well, I think those are 2 separate things.
Well, I know waiver and preservation are 2 separate things, but under the case law as it currently exists, neither waiver nor lack of preservation would be in play until the other objections are resolved, correct?
We will concede that if this court is of the opinion that the issue does not need to be preserved, then that portion of the order that requires production of documents that they assert are subject to privilege needs to be quashed and it needs to go back for in-camera review. But we still maintain that the argument should be subject to the requirements of preservation.
Well, then the rule seems to be fairly clear on its face as far as the requirement of a privilege law, but the case law that has since interpreted it has explained why you want to address the other issues first.
And I think in a case like this, Your Honor's asked, what would have happened in a perfect world? And in a perfect world, when the court said, okay, I've heard arguments on overbreadth and relevance and privilege, please submit your proposed orders. Publix would have said, and Your Honor, please note that if you rule that these documents or these requests are not overbroad and not irrelevant, we're entitled under the case law to a reasonable period of time within which to file a privilege log. So those need to happen in sequential order. So we ask Your Honor not to rule on them all at the same time.
Doesn't the obligation to, if we follow your scenario, putting Publix in the position of reviewing and logging 10 years worth of documents for 1,300 stores, does that not have a component of irreparable harm to it?
I think that, no, I don't believe it does. I believe it's onerous. But as far as my research has shown, that irreparable harm cannot be shown through costs in responding to a discovery request. And like Your Honor said, you know, if this was a case between Winn-Dixie and Publix, they'd be able to do it, and there wouldn't be any irreparable harm.
Is there, it's sort of a proportionality, then that inquiry then. There's a difference between, you know, one of us is Braveheart, Publix versus Winn-Dixie antitrust case.
Yeah.
And a slip and fall, which I assume Publix is sued for at least once a day, is somewhere in their chain.
Certainly, that is true. We still maintain that that's not the type of irreparable harm that certiorari review is intended to prevent.
Understood.
And additionally, we don't think that there's a departure from the essential requirements of the law, because we don't believe that Santos applies. Because Santos really should be read narrowly to limit discovery on the issue of actual and constructive notice. And to the extent that Santos could potentially be read to prevent all discovery relating to anything outside of the physical establishment, we would encourage this court to issue a conflict opinion with Santos.
You would agree that Santos, putting aside sort of the window dressing to get there, the holding of Santos is pretty clear in this context, and I think it's more generally applicable than you may be willing to concede. But Santos, to me, simply stated is, you can have a fair amount of discovery on this going back. We don't know exactly what that might be, but what you can't have is discovery about other locations. And that makes some intuitive sense, because the floor at this Publix, in this deli department or produce, wherever it was, is not necessarily identical to the floor at the Publix down the street from here, and the configuration of the deli and what their cameras are doing and who's watching them and all the rest of it. So I'm troubled by, at minimum, the holding of Santos with respect to, and by troubled, I mean, I'm troubled by your case, with respect to all the other stores. 1,300 is a lot of stores.
It is a lot of stores. But again, we maintain that this is an overbreadth and relevance issue that is really should be decided by the trial court and not by an appellate court on certiorari.
And so we make this rule, and every time Publix gets sued for a slip and fall, they're going to produce 10 years worth of documents on 1,300 stores for a case that probably settles in mediation for, you know, 5 figures.
I mean, if a trial court judge in his or her discretion determines that that's appropriate, that's a discretionary evidentiary discovery ruling that is within the trial court judge's purview. And it's generally not the role of this court to kind of step in and manage trial court judges' discovery, except for in extraordinary circumstances. The writ of certiorari is an extraordinary remedy. And I think that the issue, the Santos case made very clear that it was limiting it to, I mean, they analyzed the business establishment language versus the possessor or owner of the establishment language. And there are all sorts of relevant facts that go to negligence that are not covered simply by actual construction.
It's really hard for me to come to grips with the fact that a trial court order on discovery, ordering 10 years of discovery on 1,300 stores is not extraordinary. That's an avalanche of information for one case.
It is, but they've not cited any precedent that we think binds the trial court and prevents it from doing that by clearly established.
Except Santos, which did bind the trial court.
Except for, we don't believe that Santos applies in this case, because we think that that case is limited to the trial court's interpretation of discovery relating to actual construction. So unless you have any other questions, so press the mic.
Thank you. You have 2 minutes, sir.
I will try to do this rapidly. There are a series of points I want to make. The reason you don't see anything in the record about the trial court discussing the privilege log and this hypothetical colloquy that might have happened with respect to a privilege log is because trial counsel for Mr. Roth didn't raise this as an argument. All right. What trial counsel argued was, well, facts are facts, they're not privileged, we're entitled to determine facts. I invite the court to look through the hearing transcript. There is no reference to a privilege log in there. That's why there's no discussion of it. In fact, the trial court gave no guidance whatsoever, and that was part of the problem, which there was nothing to trigger Publix.
You're saying if the trial court had made an oral or preliminary ruling, Publix would have been triggered.
Exactly, but the trial judge remained utterly silent except to say, you're running out of time and submit proposed orders. That was it. So there was nothing until we received the order that told us, by the way, maybe there's a work product privilege log issue here, so that didn't come up. There was a brief reference to subsection 2 of 7680755. I just want to reiterate, subsection 2 of that statute does not create an independent basis for proving breach of the duty of care. All it says is that the common law duty